Hello viewers, this is attorney Naresh Gehi, and as always we are going to have a very interesting segment for you. Today we are going to show you a different way as to how you can get your green card in the United States. Yes, we get many calls every day wherein people tell me, Mr. Gehi, I'm illegal in this country for the past 15 years and it's time that I want to get my green card now. And I'm married, I have 3-4 children in this country, but I cannot get married again to an American citizen because I'm already married to someone who is also illegal in the United States. So now we are going to discuss about cancellation of removal, commonly referred to as a green card, which you can get if you've been present in this country for more than 10 years. So with me, I have my esteemed colleague, my paralegal Sandeep, and Sandeep and I will be taking questions and will be answering some questions in connection with cancellation of removal. And this show is very basic. The reason we try to keep our show simple is so that viewers can understand everything in easy English, so that they don't have to get confused with serious legal jargons. So now let's begin the show, and welcome Sandeep. It's always a pleasure being with you today. So as you rightly know that we are going to discuss about cancellation of removal.
Thank you.
Now, as you know, cancellation of removal commonly means a procedure wherein exactly you have to be here for 10 years and you should show that there'll be hardship, to qualifying relatives. So Sandeep, now let's start with any questions that you may have in connection with cancellation of removal.
Who can avoid deportation by cancellation of removal?
That's a very good question. Are you trying to tell me that if you are in deportation today, can you still get your green card based upon cancellation of removal?
That's what I'm asking.
Okay. The question here is that, let's take a simple example, that you actually got a notice to appear before an immigration judge. Now you're scared. Oh my God, what are my rights? And I need a very good immigration lawyer. I need a lawyer who can really defend me very well. That's where our law firm can basically first review your documents and tell you whether you can even qualify for it. So the first thing what you need to do at this stage is to ensure the fact that you have been here for 10 years. And if you have been here for 10 years, if you have US citizen children, or if you have permanent resident children in this country, or if you have citizen parents, or if you have green card holder parents, then you may qualify for cancellation of removal. Of course, there are many other things which we have to look into before a person can qualify for cancellation of removal.
If I was previously ordered deported, but I've not left the U.S., is there anything I can do?
That's a very, very good question. If you were previously ordered deported, and at this time you want to get your green card, what can you do? That's a very complex procedure. Firstly, you must try to make a motion to reopen before the immigration judge. That's one way to do it. The second way to do it is to apply for a joint motion to reopen. What is a joint motion to reopen is very important. A joint motion to reopen is a motion to reopen wherein the government, which means the Department of Homeland Security, consents to the reopening of the motion. That's one way to do it. Secondly, for example, we've had many clients who are already ordered deported in the past, and what we did is that we checked whether they actually received the notice, or whether the notice which is served upon the respondent or the client was defective. So under 239 of the Immigration and Nationality Act, if the notice was defective, then the good news is that you can try to request the immigration judge, look, for example, the date, the time of the hearing was not very clear, that's why my client could not appear. So based upon those facts and circumstances, a client can actually consider to file for a motion to reopen. Now Sandeep, the next question you might be having is what happens after the motion to reopen is granted or denied. Very often a motion to reopen can be reopened, the case can be reopened or the case can be denied. Now let's take the first scenario. What happens if the motion to reopen is granted? That is excellent. If the motion to reopen is granted, the good news is that after the granting of the motion to reopen, what you need to do is that if you have relief available, for example, if you have 3-4 children in this country who grew up here and if you've been here for more than 10 years, apply for cancellation of removal. Secondly, if your father or your mother had sponsored you, if your petition has come up at this time, you can apply for your green card. I mean, depending on the grandfathering clause under Section 245 of the Immigration and Nationality Act. So these are some of the ways through which you can actually kind of even get your green card even when you are in deportation. Now let's take another example wherein the motion to reopen does not get granted. What do you do? In this case, Sandeep, what we do is that we have to appeal it to the Board of Immigration Appeals. And if they grant the reopening of the motion, that is excellent. If not, then unfortunately you're stuck. You can even go to federal court. But, those procedures are very tricky and it can actually be kind of, very difficult. Now, on a different note, we get calls all the time, Sandeep, that, what happened is that my husband was ordered deported in this country 7 to 10 years ago. Now, what will happen if he goes back home to his country? Is that really so bad? The answer is no, it's not. We've had clients who were ordered deported and they went back to India. And thereafter, of course, we all know that they were subjected to the 10-year bar. We were able to get the client back within a period of 2 to 3 years. Now, you may be a person from the Netherlands, or you may be living, for example, in the UK, and if you overstayed your visa, and right now, if your employer has also filed a petition, and if you can show some hardship to your child or qualifying relatives, you can come back from the United Kingdom, you can come back from Saudi Arabia, you can come back from the Bahamas, you can come back from Guyana, you can come back from any country in the world, you can come back from Australia. So the question is that it all depends on the strategy which is adopted by the law firm. And also it all depends on whether exactly the lawyer is guiding you properly in this case. So with your lawyer, you have a relationship wherein exactly you should have a relationship where you have a very open conversation. And the duty of the lawyer here with the client would be to address the issues and let them know what the options are. But no lawyer can ever make a decision as to how the case should be proceeding further. So those are some of the issues which people have to consider in terms of actually, making the right decisions. And that is very important.
Are you in deportation? Do you have a complex immigration matter? Has your immigration case been denied? For all your complex immigration matters, including family-based immigration, employment-based immigration, deportation, citizenships, battered spouses, call Gehi Associates at 718-263-5999 for a free initial consultation.
Over the years, we've helped many people in getting the green cards. Would you like to have your green card? Call Gehi Associates now.
If I'm in removal proceedings, can I renew my work permit?
That's a very good question. If you are in removal proceedings, can you renew your work permit? Depends on the facts and circumstances of the case. Of course, if you have an asylum proceeding pending and if the clock starts, then of course you can renew it. If the clock is stopped, then the answer is no. But if you are in cancellation of removal, you can renew it. And if you're married to an American citizen, and if you are in removal proceedings, the answer is that yes, you can renew your work permit. And I understand that not many people know these facts, that they can renew their work permits even when they are in removal proceedings. That is one reason, Sandeep, why we actually prefer taking up complex cases. Because whenever it's a complex matter, it is very important for the client to know his rights. I mean, especially it can be a complex H-1B matter, can be a complex deportation matter, can be a complex family-based immigration matter. The law's job is actually to do the right research and let the client know very clearly as to what his rights are and under what section of the law you're talking about. And the client has every right to know under which part of the code are you talking about. Are you speaking under 8 CFR 1.1Q? That's an arriving alien issue. Or are you speaking about basically some other part through which they can get an adjustment of status? So those are questions which exactly are very important, because only through the law you can make decisions for the client. By just telling the black letter law to the client and just not explaining him properly is actually doing injustice to the client here.
Attorney Gehi, in the context of cancellation of removal, what does continuous physical presence mean?
Continuous physical presence means that if a client has left the country and come back, he should have had the intention to live here, and I would say that it should not be for a long time. If he goes outside the country and comes back, for example, he cannot go there for more than 3 months or 6 months and come and live over there and then come back, then you've broken the chain. So the question is that there are certain factors which are considered, and that's a very subjective question actually, and we'll have to prove it to the judge, for example, on some cases, that he has been living here. For example, the easiest way to put it, you should be living 10 years continuously in the United States in order to be eligible for cancellation of removal.
What period of time spent outside of the United States will break a person's continuous physical presence in the U.S.?
As I said earlier, that depends on the facts and circumstances of the case. And in some cases, it can be basically if the judge feels that, yes, I mean, even if you, for example, this is just an example, if you've been out for more than 3 months also, that can be an objection. If you've been out for more than 6 months, there can be an objection. Those are subjective issues because some people take multiple trips. So those factors depend on the facts and circumstances of the case.
What does exceptional and extremely unusual hardship mean?
Extreme, exceptional, and unusual hardship is the case law on the point. And there are 3 leading cases in this matter. One is the matter of Resinas, that's a controlling case law. And the other one is the matter of Monreal, Monreal. And the third one is the matter of Andazola. So that, according to this particular case law, you have to show that if your children or if your parents who are citizens or green card holders, they will suffer from extreme, exceptional and unusual hardship. For example, if things are really bad in a country, for example, like right now, Rwanda, Pakistan, and what's happening in the Middle East right now, if you can show that things are not very good out there, then, I mean, you can prove, or if you can show that your child will not get, proper medical attention, or if you can show that, they won't get the right educational qualifications in the home country. All those are hardship factors, and that's where the lawyer should be working very closely with the client.
If I have an order of deportation against me, can I still get immigration benefits?
Unless and until if the deportation is not reopened, you cannot qualify for immigration benefits.
If I have been in the U.S. for a long time, can I obtain a green card?
If you've been here for a long time and if you're illegal, if you came in on a B1, B2 visa, like many of my clients who come in and see us, they get married. The reason they get married because within 6 months you can qualify for a green card here. So that's one way. Secondly, if you've been here for a long time, if we can show hardship to children, that's another way to do it. Thirdly, I mean, if your country conditions change, for example, if you remember in China a while ago, they had a major crisis. If you remember the Tiananmen Square crisis, at that time people started applying for political asylums because they couldn't go back. So if country conditions change, you should consider political asylum too. So there are ways through which people can qualify for a green card. For example, I mean, recently, we had a client from Haiti who actually qualified for cancellation of removal. She had a TPS, which is temporary protected status. And what happened in this case was that we were able to show the hardship to the father and to the son. And the judge was extremely kind, and the government was very kind, and they said that they cannot go back to Haiti and live there. And the wife qualified for a green card in the United States. So remember one thing, that even if you are in deportation, does not mean that you cannot come out of deportation. You should fight your deportation. Don't give in. Which means if you have rights, fight for them. That's what American law is all about. And if you fight for your rights, there's a very good chance that you may qualify for a green card in this country.
Can my children benefit from my cancellation of removal?
Under the law, you have to file a separate application for them.
Okay.
Which means it's not a derivative application under the law. Which means you have to file an EOIR 42B for each one of them separately. You cannot just basically say that you can include them in this application. The answer is no. Sandeep, you've been very kind to ask me some excellent questions. Now, we're just going to have a final roundup of what was discussed today for the benefit of our viewers who want to get the green cards through the 10-year presence in the United States. If you've been here for more than 10 years, and if we can show hardship to your children in this country, or who are U.S. citizens, or if we can prove hardship to your parents who are permanent residents or green card holders, people forget that you can even show hardship to the parents. Even that qualifies you for a green card. So if we can show those factors, and if we can prove extreme, exceptional and unusual hardship under Section 240 of the Immigration and Nationality Act, The answer is that you can still qualify for a green card. This is one way for you to get your green card, qualify. I mean, for the green card. The other way, as Sandeep discussed, what is the other way? The other way is that you need a bona fide marriage, which means if you're marrying someone for love, if you came to this country with a visa, then within 6 months you can qualify for a green card. These are some of the shortcuts, and other than that, we'll also be discussing, some other issues here with Sandeep. Sandeep, you asked me a question, before this particular segment started, that if a person came in on an H-1B, and if his H-1B is expired, what should he do? That's a very good question. If you came in on an H-1B, and if your I-94 has not expired, the good news is that you are not subjected to the 3-year or the 10-year bar. You need to get another H-1 from some other company, if possible, and you can go outside the country, get your passport stamped and come back, because you're not subjected to the 3-year or the 10-year bar if your I-94 has not expired. And this is a big confusion which many companies have and many people have asked us over the years, especially because we also have helped a lot of corporates in connection with the ID matters, information technology professionals. So the answer to that question is that even if your I-94 has not expired, you're still within your status in a sense that you're out of status, but you're not accruing unlawful presence. So get your acts in order before you come to a stage that you accrue unlawful presence in the United States. So friends, we have a lot of different topics to talk about. It was a pleasure being with you, Sandeep, on the show today.
Thank you, Attorney Gehi.
And if you have any further questions, come in and see us for a free initial personal consultation. This is Attorney Gehi from Gehi Associates. We'll be back again with some more interesting news from the world of law.